questions and things like that. So as usual, today we will begin by getting some questions from you. We will try our best to answer them in the next 7 to 10 minutes. Thereafter, we will proceed to our mock orals. So for now, anyone with any question, please put your hand up. Then we hear your question and then we will try to answer them. So maswali, watu wangu. Any questions today before we begin? All right, silence means that there are no questions. So I believe we can begin. So who is going to be our first volunteer today? All right, Njeru Alice. Thank you for being the first volunteer. Please unmute. Good evening, Alice.
Good evening, Angelo. I wanted to try, yes.
Okay, thank you. So Daniel and I will ask you a few questions and then we'll try to give our response afterwards. Is that okay?
Yes, okay.
All right. Daniel, please begin and then I will come after you.
Okay, all right. Good evening, Alice.
Good evening, Daniel. How are you?
I'm good. How are you?
I am good, thank you.
Kindly just introduce yourself.
A good evening. My name is Anjeru Alice Karia. I'm a student at Kenya School of Law undertaking Advocates Training Program. I am in Class D, Form 16. My registration number is 2023-0993, and I'm ready to proceed.
All right, that's proper. So I'm just going to ask you a few questions and we'll be quick and fast and done before you know it. So, Alice, what's your favorite unit at KSL?
I do not have favorites at the moment. I'm trying to balance like all of them.
Okay.
Yeah.
Okay, that's fine. If someone asked you, what's the meaning of this word, dominus litis?
Dominus litis is a Latin word that means that the person who instituted the suit is the master of the suit. So basically, they have a right to begin in proceedings in court.
All right, that's okay. So I don't know if you've heard about the case of Giela versus Castman Brown.
Yes, I have heard about it.
Yes, what is it about? And please try to explain the meaning of each and every element.
Okay, thank you. Giela versus Castman Brown is a case that talks about temporary injunctions found under Order 40 of the Civil Procedure Rules 2010. It provides for rules which the applicant must prove before the temporary injunction can be granted. So one of them is they have to prove that they have a prima facie case. So this prima facie case has to have a degree of success. So basically, a prima facie case is a case that, from the facts of the case, you can see that it is very, very likely it's very likely to okay, the word is disappearing, but a prima facie case is a case that on the face of it, without needing the adduction of evidence, it can go through the proceedings. And then number 2, the applicant has to prove that they are going to suffer irreparable injury if the injunction is not granted. So an irreparable harm generally means an harm that cannot be equated into damages. So maybe they are going to suffer something that cannot be compensated by damages. And then the third element is that the applicant has to prove that the balance of convenience is on their side. So basically, what the court is going to consider is who is going to be more aggrieved by the fact that this injunction is not given. So if the applicant can actually show the court that they will be more aggrieved by the fact that the court fails to issue the injunction, then the court is going to consider the applications. Thank you.
All right. Yeah. So can you just explain for me the difference between a leasehold interest, a freehold interest, and a license interest?
Sorry, a leasehold, license, and freehold.
Yes.
Okay, thank you. So a license basically is a permission. Basically, it's like a permission you give someone to access your land for purposes of doing something. So for example, let's say I have land whereby I have trees and I have sold those trees to someone. So I'll give them a license for purposes of accessing my land and cutting the trees that I've already sold to them. So this permission, if I had not given it to them, it would have been considered as trespass. Then freehold is it is where I own land absolutely. It is mine. So absolutely, I do not have to kind of return it to someone else after a period of time. So when we talk about leasehold, it is the exact opposite of freehold. So leasehold, you usually lease up to a total term of 99 years. Sorry. So 99 years, then it reverts back to the headless. So, or you can lease it from depending on the years that you want to lease. So a leasehold, you have exclusive possession for a term of a period that you've agreed with the lessor. But for freehold, it is absolutely yours. The right is just indefeasible. Yes, that is what I understand.
Okay. So person X has come to your office. They want to transfer their property to another person, person Y, and
Yes.
this property is located in Nairobi. Now, through the Kenya Gazette notice, he tells you or she tells you that this property has been gazetted. This property has been gazetted for conversion, and they would just like to understand the meaning of this term conversion, what it means, and the process of conversion.
So it has been gazetted for conversion.
Yes,
Is
but
that
they're struggling to understand the meaning of this term conversion, and it is in their interest to transfer this property to another person. So they'd like also to understand the process of conversion apart from its meaning.
okay? My understanding of the client would be that if the property has been gazetted for conversion, that means that probably it was a freehold property which is owned by my client, but maybe the government wants to take this land for purposes of public interest or public purposes. So I would think that conversion then would mean that the government wants to compulsorily acquire my client's land. So basically under section 107 all the way to 133 of the Land Act, that means that land which is already, which has been identified as one that the government is interested in cannot be transferred. The person can transfer, yes, but then the transferee can have an interest, can have a legal recourse against the transferor. So I would actually advise my client not to transfer this land for the moment and probably wait and see. Probably wait and have a conversation probably with the Commissioner for Land for purposes of understanding the whole process of public acquisition of land.
Okay, thank you. Angela?
Okay, thank you, Alice. You are also going to have a few questions from my end, and maybe mine are also straightforward. So my first question to you, Alice, is, let's say, I don't know at KSL, are you aware of something called 10P?
Yes,
Okay.
I have heard of it, yes.
Very well. So, and you are aware that I might be admitted this year as an advocate of the High Court of Kenya, right?
Now I know. I didn't know that.
So now, when we were doing our bar examinations, one beautiful lady from the famous Class F caught my eye at the examination center at Cooperative University of Kenya. So we agreed, some things happened. Unfortunately or fortunately, she got pregnant, and now she doesn't know what to do. So we have rushed to your office for some guidance, because now we want to have abortion or something like that. But you yourself, you don't believe in abortion. But we have come with a brief to you whereby we need you to advise us accordingly on the way forward, or we are asking you to handle the matter. Can you please tell me, what would you do?
You want to abort?
Yes.
Yeah. Okay. Okay. I would for currently the position I have for abortions. I cannot remember the particular case. Abortion is illegal. Yeah. So really,
You see, Alice,
yeah.
your religious and cultural belief cannot allow you to help
Yes.
her matter.
Yeah. That is.
What would you do? So leave alone about what the law say.
Oh, what I would do?
How are you going to handle this matter? What will you do?
I'll just tell you what the law says, and currently the law says that abortion is illegal. So giving you any other advice which is contrary to that, then would make me an accessory to a crime.
Okay.
Yes.
Thank you. So now, Alice.
Yes.
What is caveat emptor?
Yes.
And what are its exceptions?
Okay. Caveat emptor, I understand it to mean buyer beware.
Okay.
And I do not really have the exemptions, but I would try by saying sale by public land can be exempted. Sale by public auction can be exempted from the concept of caveat emptor, because this person now does not have all the time to do the due diligence and all that. That is what I would say for now.
Okay, thank you. Have you studied movable property securities rights at the Kenya School?
Yes.
Okay, can you please give me at least 5 challenges of using movables as security?
Okay, kindly allow me to give you the ones that I remember at the moment. One, there is no for using movable property, yes?
Yes.
Okay, movable property is like, for example, the quality fluctuates over time. So you might find that probably something that was really expensive at the moment when you're taking the loan or is currently ranging very low. So that is uncertainty in terms of movable properties. And then lack of proper legislations for movable property. So for example, you find that in registration of notices, you need to register notices in different registries. So you can have MPSR registry and you can have company registry. So the fact that we have a couple of them, we need to have like a consolidated legislation that deals with movable property. And then movable property is it's escaping my mind. Oh God.
Okay, you are doing well. You are doing well. My second last question to you is,
Yes.
who is an administrator? Okay, have you studied insolvency?
Insolvency, yes, we have.
Okay, please tell me who is an administrator
Yes.
and give me at least 3 roles of an administrator.
Okay, an administrator is a person appointed by the company and the creditor. Okay, first, an administrator comes from the administration process, which is usually an alternative to liquidation. So an administrator is a person who basically ensures that instead of this company being liquidated, that the company basically runs as a going concern for purposes of achieving a better outcome compared to if the company was liquidated. So under this, I cannot remember the section of the Insolvency Act. The administrator has the power to the administrator has allow me to pass that. I cannot remember. Thank you.
Okay. Then finally,
Yes.
what are the roles, or give me at least 2 roles
Yes.
of an insolvency practitioner?
The roles of an insolvency practitioner. Okay, for example, if we are talking about let us talk about insolvency practitioners in terms of people who are ensuring that the company is running as a going concern. So their role is to make sure that the assets of the company are preserved for purposes of the running of the company and for the benefits of the creditors. And also, if we are talking about now, for example, let's say, for example, a bankruptcy trustee. A bankruptcy trustee basically ensures that the creditors are well taken care of, as well as considering the interests of the debtor. Thank you.
Okay. Thank you. Thank you so much, Alice. I think I will go first in giving my review, and then Daniel will follow afterwards. So what I can say as my general comment is that when you started, you said that you are just trying, but actually you did really well. You are concise. Your answers were not everywhere. You were just straight to the point. It shows that you have read, and that is really, really, really good. So congratulations. So the first question that I asked you, I didn't intend to tell you that I might be a father, but I wanted to test whether you have read something about Kabrang rule. Okay. Have you read? Do you know anything about Kabrang rule?
Yes, I do.
Yeah. So that was the test on the fact that when a brief is brought to you as an advocate, you don't have any choice. It doesn't matter. Be it abortion, be it, let's say, matters relating with rape, murder. So you cannot send away any client who has come to your office because of whatever you believe, either cultural or what. No. So what was being tested there was whether you know something about the application of the Cabranc rule. and what it entails, such that the Kabrang rule does not allow you to reject a client's case unless under the exceptions. For example, if you would have told me that I was testing you about Kabrang rule, then I would have proceeded now to ask what are the exceptions or if the rule is absolute. Okay? Whereby now I can give you two exceptions, but I believe they are about four, or if they are two, you are the student now. So there are a few exceptions to that rule. That is the conflict of interest. And then it can be another one is when you don't have the expertise in the area of law in which the matter is premised. Okay? So in that case, I was testing you about Kabram rule. All right? Then the second aspect, caveat emptor, you answered it well. So it means that the buyer be aware. Okay? The exceptions include the following. Number one, that is if the sale was by a sample. Number two, misrepresentation by seller, where the sale was by description. So caveat emptor is not something we can say will be in your bar examinations, but someone will ask you during oral exams. You did really well on the aspect of the challenges of using movable property, movables as security. So the challenges include as follows. Well, number one is fluctuation of the market. Sometimes you don't understand. At one point, motor vehicle is this amount. The next, we don't know what has happened in Russia. Then the value just depreciates. Okay. Number two, we have something called the issue of commingled goods. Okay. I don't know if the lecturer explained to you something called commingled goods, commingled assets, commingled what. Anyway, this is something that Daniel do deal with day in, day out. Number three, we have movables can be sold, yet they are collateral. Number four, lack of a standard way of describing movables. Number five, difficulty in establishing that the movables are already encumbered. Then number five, depreciation of movables. So at this question, you are really on point. But now I would proceed to ask you to go and read these cases. We have one case is known as Twine's case. I believe if you are told by Mr. Wakimani, this is something, maybe it is somewhere in your notes. You need to read that case. And then we have DL Sign versus Kenya Insurance Limited, 1955. Then on the aspect of administrator is not appointed by the company or the shareholders. An administrator is a person appointed by the court to maintain the company as a going concern before handing it over to the directors. Okay? So some of his or her roles include, for example, one, putting the company back to profitability. Number two, control the company's assets. Number three, do business with the aim of paying off creditors. Then number four, realize the assets of the company so that they may pay the creditors. Okay? And that one, my final question was on the role of insolvency practitioners. You really answered that well. So that one, I would say you go to your Insolvency Act. Okay? Look at Section 6 and look at those other roles. So that is it on my end. I would give you a lot of marks. Yes, a lot indeed. So unless if you have a question for me, I would hand the mic to Daniel.
Sorry, I did
Can you
not
repeat
hear the exceptions of caveat emptor.
One is sale by sample.
Yes.
And then the other one is misrepresentation by seller, where the sale was by description.
And the cases for insolvency, we've not done those, but can you repeat them again?
They were for movable securities. The Twine's case, I believe you Twynes, that is TWYNE
Yes.
apostrophe, then S case.
Yes.
Then the other case is DYAL.
Yes.
Sign, that is SINGH, versus Kenya Insurance Limited, 1955.
Thank you. Thank you so much.
All right, you're welcome. Daniel?
Thank you, Angelo. Alice, you can hear me, right?
Yes, I can.
Okay, Alice. So, in my opinion, I think you did very well in relation to my questions. You answered them very well, and I like the confidence, Alice. I like the fact that you're able to. You're very clear in your answers, and your explanation was very good, especially in relation to the Jela versus Cashman Brown case, which I think you explained proper. It's something that someone can take to the bank. Now, I know there's a question that I asked you, and I think you had an issue answering it. Maybe could you know which question that was?
I'm thinking the last one, this case scenario.
The
conversion.
Yeah.
The conversion.
Yeah. So yeah, I think that one threw you a bit, threw you off your feet. But I like the fact that you tried anyway. You tried anyway. Now, Alice, whenever you are trying, please, it's important that you let the lecturers know that you're trying, that you're giving it a trial, so that you don't misguide or mislead the lecturers, for the lack of a better word. So whenever you're trying, whenever you're not sure, please just let the lecturers know that, okay, I'm not very sure about this question, but let me try, so that whenever they're listening to you, they're listening to a trial and not, you trying to answer the question. All the answers that you gave me before, all the answers that you gave me on the other questions, I think they are correct and proper. I don't think there's anything to add. So conversion, I think this is something that maybe all of us here have to take very seriously. All of us here have to take conversion of properties is very serious. It's something that is alive. It is something that is current. It is something that we must just know about. This is some of those things that for conveyancers, it might appear, in our lives for quite a long time now. Currently, conversion is only happening in Nairobi for Nairobi properties. That's the pilot project. But I want to believe that, maybe the next county is going to be Kisumu or Nakuru or wherever. But for properties in Nairobi, the conversion process already begun, and a lot of properties, probably, many properties have been converted. Now, what is the process of conversion? What do we mean when we talk about conversion? So conversion means the transitioning from the current regime of manual process of transactions in land, meaning the manual process, meaning, going to the lands registry, taking the things there, standing in a line, waiting to book your property, or if you want to transfer, you have to go there with the hard copies of the transfer document, the completion documents, you have to take them there and all that stuff. So we are transitioning from this current regime of manual process of transactions, registration, and everything else when it comes to land, to an online process of transactions in land. Meaning now, if you want to do a transfer, you can do it from the comfort of your desktop. If you want to register a charge, you can now do it from the comfort of your laptop or a desktop. You don't have to go to the lands registry and make a long line waiting for this and that to be done. You don't have to send a clerk to the lands registry to do a search. You can do this from the comfort of your laptop. So conversion means the transitioning from the current regime of manual process of transactions in land to the online process of transactions in land. This is done through a platform called Ardhi Sasa. I want everyone to listen to this very carefully, because right now in Nairobi, you cannot do any transaction. You cannot undertake any transaction in relation to a property that has been converted or gazetted for conversion unless and until you have gone through the conversion process. So I believe that this is a question that could easily find itself in your oral questions. So it's nothing crazy. It's nothing unfamiliar. It is basically the transitioning from the current regime of manual process of transaction in land to the online process of transaction in land. And I think I've explained what that means. Now, what is the process? What is the conversion process? The first step is gazettement of the property in the Kenya Gazette for conversion. Gazettement of the property in the Kenya Gazette for conversion. So it must be that the property has been gazetted in the Kenya Gazette for conversion. You cannot just wake up in the morning and say that, oh, me, I'm going to do conversion because, oh, I'm told this and this and this and this. So the first thing is gazettement of the property in the Kenya Gazette for conversion. This is done by the Ministry of Lands, I believe, or the Land Registry's Office. Then the second one is creation of Ardhisasa accounts. For advocates who are doing conveyancing, I want to believe that they already have Ardhisasa accounts, but if you don't, then you have to create your Ardhisasa account, and the vendor or the owner of this property must also create an Ardhisasa account. If you intend to do a transfer, then even the person who is to be transferred to needs to have an Ardhisasa account, because this online process is happening through this platform. It's happening through the Ardhisasa platform. Faith Waithera, your video is on, so maybe you can just close it. Yes. So the next process is creation of Ardhisasa accounts by the vendor, the advocate, and where we have a purchaser by the purchaser, where we have a chargee by the chargee, because everything is done online. Number 3, the advocate makes an application for conversion. Now, the application for conversion, when you go into the Ardhisasa platform, you'll realize that any application in relation to transactions in land, the applications can only be generated by the advocate. The applications can only be commenced by the advocate. For the vendor, even after they've created their Ardhisasa account, they're not able to commence anything. This gives us that monopoly to lead these guys through this process, to make money too. I mean, I know you're public servants, but that is not all. So creation of a sales account. Then 2, the advocate makes an application for conversion. This is also done through the Ardhisasa platform. 4, consent for the conversion of the property by the proprietor meaning the owner of the property, by affirming an electronic signature in the Ardhisasa account. So through this, they're consenting to having the property converted from the old system of registration to this new system of online. I mean, the old system of manual process of transaction in land to this new online system or process of transaction in land. So they have to consent to this. How do they do this? They affirm an electronic signature on the Ardhisasa platform. So they'll go to their Ardhisasa account, they'll view the new transactions, and they'll be able to see this application by this advocate, then they just consent to it. After that, the advocate uploads the title to be converted on the Ardhisasa platform. So the uploading of the title to be converted, the title that you have which is to be converted in the Ardhisasa platform. The uploading of the title to be converted on the Ardhisasa platform. So you just scan it, then you upload it. The next step is verification of the uploaded title by the Lands Registry. Verification of the uploaded title by the Lands Registry. This means the Lands Registry goes through this title that you have uploaded. They confirm that it is authentic. They confirm that whatever it is in the encumbrance section is what they have in the deed file. Everything that is appearing in this title is what they have. Their deed file or their manual registry contains the same information that is in this particular title. And you've not just uploaded a title from River Road. It is exactly the same title. So they have to do verification. Then after that, surrender of the hard copy title to the land registry. Surrender of the hard copy of the title document, the title to be converted, surrender of the hard copy of the title document to the lands registry. Then lastly, issuance of a new or rather converted title by the lands registry. Issuance of a new title, or if you like, you could call it the converted title by the lands registry. Now, during verification, the lands registry might try to verify and realize that whatever you have is not proper. Now you'll have communications with them. You will correct whatever is not proper. We will explain why there's a difference from whatever title that you've uploaded and what they have in the deed file. It is only after verification that you can surrender the property, the title for conversion, and it is only after that that you'll be issued with a new title. The reason as to why we are doing this is to ensure that we don't have fraudsters, uploading people's properties or making photocopies of people's properties and taking them to the lands registry and getting a new title, yet the property doesn't even belong to them. Now, another reason as to why the proprietor has to have another license account and they have to consent to this conversion process again is to ensure that we are not going through a process of fraud. We don't have new titles which have been obtained fraudulently. So the proprietor must affirm their signature before the advocate can proceed. The advocate must upload the correct title before this surrender can be requested for, before this new title can be issued. Guys, I hope that was very clear. I hope now we understand the process of conversion. And if you ask this in exams or during orals, at least you'll have an idea. Now, I've said that this is ripe. This is something that is happening right now. It's a big deal. You cannot do anything in relation to a property that has been gazetted unless and until you have gone through the conversion process. You cannot discharge it from anything. You cannot charge it. You cannot transfer it to anyone. You cannot register anything on this property unless you have an exclusion, an exemption, which is very, very hard to get. It's not easy. So basically, you will be forced to first do the conversion process so that you're able to deal with this particular property. Alice, I hope that was clear.
Very, thank you.
Thank you, Alice. Do you have any question for me?
No, thank you.
All right. Fine. Thank you. Angelo, I think you can take it away.
Okay. Thank you, Daniel. Thank you, Alice. You really did well. Please keep reading, keep revising. You can only get better. Okay. Our next volunteer, please raise your hand. Guys. Okay. We have two people, I believe. Gishu, why are you? Gishu, Faith, and then John. All right. Faith, please unmute. Then John, you will come next. Thank you. Thank you both. All right. Good evening, Gishuru. Sorry, Gishuru.
Good evening. Yeah, good evening.
All right, right. Kindly introduce yourself.
Okay, good evening. My name is Faith Ishuru. My admission is 2023-03-18, and I'm a member of Class B.
Okay. You are a member of Class D.
B.
Who teaches you?
B for boy.
Oh, B for boy.
Yeah.
Who teaches you probate?
Sorry?
Who is your lecturer for probate? Probate and administration. Who is your lecturer?
Miss Ruto.
Ruto.
Yeah.
Okay. Can you please tell me what you understand about Section 3.5 of the Law of Succession Act?
Okay, according to Miss Ruto, according to Section 3.5, it talks about the people who are catered for under Section 3.5 who are not absolutely catered for under the Law of Succession Act, and this could include former spouses who have not been married. Say, for example, you are divorced, but you are a divorced wife or a divorced husband. And I'll give an example of a divorced wife. According to Ms. Ruto, if you are a divorced wife and you are not married, then the Law of Succession Act favors you when it comes to ownership of property, of lifehold property, the life interest of the property of the deceased, yeah, such that you can hold the lifehold interest of the property.
Okay, thank you for that answer. Have you read the case of City of Hippo versus Desmond Peters?
Yes, I have.
Okay, can you please, let's say Mr. Desmond Peters has been brought to court, okay?
Yes, yes.
And now, since you don't want your client to be taken to remand, so
Yes.
you are supposed to make a bail application.
Yes.
Can you please make a oral bail application on behalf of your client?
Okay. Okay, Your Honor, my client has been accused of stealing, and it is our submission that Desmond Peter is not a thief, was not caught stealing. There is no evidence of Desmond Peter stealing, and therefore, and also Desmond Peters does not have a risk of not attending the court, and it is our prayer that you grant him bail pending the bail pending trial.
Okay, thank you. All right. Can you please differentiate for me between review and revision?
Yeah, sure.
Yes.
So a review is when the court looks at its own judgment, and this is usually on the face of the judgment, and it includes such issues as the error on the face of the judgment. For example, I can talk of a mistake. You can have a review where there was an error in calculation, say for example, when it was coming up with the issue of the one that it was giving. Then a revision is more so the same as a review, and a revision is usually by an higher court, and basically the higher court looks at the one that the lower court gave. Yeah, so that's what I can say about that.
Okay.
It is usually about a revision of the judgment.
Which judgment?
Yeah. And then a review, it is on the issues of error on the face of the judgment.
Yeah. Quickly, finally, please state for me 3 ways of investigating a title.
Sorry, what?
3 ways of investigating a title to a land.
Yeah, there's 3 ways. First of all is you can do a personal search. You can do an official search. A personal search is where you do you personally look at the file, and then you can make an application for an official search. This is where you usually pay a fee, a prescribed fee, and the registrar issues a certificate of search. And then there is an historical search. This is where now you endeavor to go to the root of the property. That means you go to the start of the property. It includes going to issues of even allotment. So from the issue of from allotment, who was the person who was allotted from the government? Yeah. So those are 3 ways of doing investigation of a title.
Okay, thank you. I will hand you over to my colleague Daniel to ask you a few questions.
Okay.
So, how are you?
Good.
Okay, that's fine. I just have a few questions for you. This will be very, very quick.
Okay.
Now, yeah, Faith, could you tell me the different types of companies? Let's say someone has come to your chambers and they want to establish or rather start a company, and they're interested to know the different types of companies that we have.
Okay, we have 3 types of companies. We have public, we have okay, we have 2 types of companies. We have public and private companies. And then it also depends. When it comes to private, you want to know what type of private company you want to endeavor in, such that we have company limited by shares and company limited by guarantee. By guarantee means that there's that start-off capital that you
Excuse me,
give to the.
Faith.
Okay, sorry, yeah.
Sorry to interject. So are you saying that a private company can be limited by guarantee?
Yes, you have companies, private companies limited by guarantee and private companies limited by shares. Yes, correct.
Okay.
That is what I said. Yes.
All right. I'd also like to understand if you talked about public companies and a private company. What's a public company and what's a private company?
Public companies, these are companies that you buy shares, initial notice, they issue a public initial notice, and these are usually advertised. However, for private limited companies, you can buy shares through individuals.
Okay, proceed. Go ahead. You're talking about limited and unlimited.
So, under private limited companies, it means you are limited to the number of shares that you own into that company. And unlimited private companies, it means that your share is unlimited, such that your liabilities are unlimited. Yes.
All right. That's fine. Now, what are they'd also like to understand the different types of partnerships. So what's a partnership and what are the different types of a partnership?
A partnership is where you come up with you gang between 2 or more people, and there are different types of partnership. There are partnership that are limited liability partnership, and there is unlimited liability partnership. And for limited liability partnership, your liabilities are limited to the contribution that you have made to that company. And for unlimited liability partnership, it means that you can be held liable. Oh, sorry. There is actually 2 types of limited liability and limited. No, sorry, you have only 1 types of partnership, limited liability partnership. And for limited liability partnership is where individual partners are limited to their contribution to that company. Yes.
All right, Faith. Thank you so much. That's all from me.
Thank you.
Angelo, maybe you can go first.
Daniel, you can go first.
Okay. Faith, I asked you two questions, and the reason why I asked you why, I mean, when you're talking about limited companies, do you mean a private company can be a limited company? I think that was just to maybe raise a point. If you look at Section 9 of the Companies Act 2015, you'll realize that a private company cannot be limited by guarantee. One of the characteristics of private companies is that a private company cannot be limited by guarantee. So a private company is only, if it is limited, it's only limited by shares. A private company, just look at your act, Section 9, maybe even you can open it right now. A private company cannot be limited by guarantee. Then Faith, I think I gave you such a good chance to just get all the marks here. So when you're explaining what a private company is and a public company, it is important that you just have given you the opportunity to delve, like to just go as deep as you can in relation to this. So you could have talked about, when you're talking about a private company, it restricts members' right to transfer their shares. There's limit on the members to 50. You cannot have more than 50 members. It prohibits invitation to the public, for new subscribers and that. Then you're talking about public companies. It does not restrict, the invitation of public members to subscribe to its shares. It does not restrict transfer of shares. There's no restriction as to the number of, people who can subscribe to these shares. It's certificate of incorporation state. So then after that, now you go to limited companies, then you go to, unlimited companies. And, I really gave you that opportunity to do all that. So Faith, when you get such types of questions, just try as much as possible to use it, just use it effectively. And that's why I kept asking you, what do you mean by a public company? What do you mean by? So just delve into this as deep as you can, and you'll realize that you get very, very many marks. Now, again, Faith, just to emphasize, now you've done well. At least you have an idea of what we are talking about. But try and make the lecturers understand that when you leave that room, they're not saying at least you have an idea of what you're talking about. Let them understand that you know your stuff, Faith. Now, when it comes to different types of companies, it is important that you know the types of companies. So maybe just take your time. I don't want to say that you didn't give me all the answers because you didn't know. Of course, I feel like you answered them haphazardly, like you didn't really delve into what they mean. Yet that is what my intention was. Yes, you have an idea, but when you go for your orals, just a tip that I can give you, ensure that you delve into it. Don't leave the lecturer saying, oh, at least she has an idea. At least she has a general idea about it. No, explain to them what it means. Explain to them as if you are explaining to a child, that when you leave, they know that, that lady really understands what a public company is. That lady really understands what, a private limited company. Ensure that you explain every single bit. Now, I'm not telling you to talk about it forever, but ensure that every important part of these companies is well explained. I realize that is something that you did not do. Yet I only had 2 questions. Then again, partnerships. I think you had a problem with the limited partnerships. So Faith, again, this is something that you really have. Just try your best. When you get these questions, delve into it. Explain what a partnership is. Explain the different types of partnerships. If you can, throw in a few advantages of having this as opposed to the other one, this as opposed to the other one, as quick as possible, of course, within reasonable time. But what are the different types of partnerships that we have? I think that is what is really important. Now, from the answers you've given me, I can say, oh, at least she has an idea, but I don't believe that is all you want. You want the lecturers to know that you know your stuff, you know what you're talking about. The different types are general partnerships, limited partnerships, and limited liability partnerships. I realize you talked about unlimited partnerships. Faith, if you go through the act, you won't see anything or any partnership called a limited partnership. We have a general partnership, we have limited partnerships, then we have limited liability partnerships. So just try. I know it would be comfortable for us to say, oh, unlimited partnerships. When I say that, I mean general partnerships. Just try and ensure that you think of what is there. So they're called general partnerships. Now, in general partnerships, what do we have? We have general partners. Everyone in this partnership does what? Is responsible for the day-to-day running. Like, just get into it. Is responsible for the day-to-day running of the business. For all of them, their liability is unlimited, meaning in the event that there's some money owed and the partnership is not able to pay, then the courts would go for their personal property, full stop. Now, then you go to limited partnership. What is a limited partnership? In a limited partnership, we have one or two, or the number that you decide to choose, general partners who are responsible for the day-to-day running of the business. And we also have silent partners who do not run the business but are called limited partners. For the limited partners, the liability is limited to the amount of contribution that they make to the partnership. For the general partners, they have unlimited liability, meaning in the event that there's a debt and the company is not able to pay and the partnership is not able to pay, then we could use the personal property to pay for this debt. And as as one character of a company, the partners are jointly and severally liable. Just throw in those things. And now we talk about limited liability partnership. This is such a great partnership. Why? It has both the characteristics of a company and the characteristics of a partnership. Why? It does not pay, because it's a partnership. It does not pay tax. It does not file returns. It is not audited publicly. Things like that. Now here every partner has limited liability. Meaning here we don't have a general partner. Every partner has limited liability, meaning they're only liable to the amount of contributions that they've made to the company. Full stop. Faith, I want to believe that, and I think you agree that from my answers and yours, there's a difference, right?
Thank you. Thank you for your feedback. Yeah.
Now I know that probably you know everything that I've talked about, but you just talked about it haphazardly, like just talk about it generally. Probably you know everything I've said, yes. So just make the lecturers understand that you know your stuff, okay, Faith?
Okay.
Thank you, Faith. All the best. All the best, Faith.
Thank you.
All right, Faith, you did quite well. So it is just same as Daniel have said, in the sense that you have an idea, but you refuse to go deeper. I don't know if you think that it is enough what you have said, but because it is not that you don't know per se, you actually know, but you are just like a mile away from, let's say, putting it to bed. So don't let the panelists guess what your answer should look like. So just give them that sense of completion. For example, when we are talking about the city of Hippo versus Desmond Peters, so from your answers, I understood that you have read this particular case, okay? But now you see, when making bail applications, the aspect of the facts per se does not matter, because what you are what you are going after is to secure the liberty of your client, okay? So in the sense that even you will not delve much about the facts, but what is the position of the law with regards to bail pending trial, okay? For example, if I were you in this particular instance, so you would first determine, is Desmond Peters, according to you, is he a minor or an adult, such that we can know how are we going to apply for this bail. Is he a minor or is of the majority age?
A minor.
He is a minor, right?
Yeah.
Anyway, even if he is a minor, still the principles relating to bail will still apply. And you will see, Your Honor, I would like to apply for bail at this particular time. As you can see, the accused in this court is a minor, and therefore it does not pose any threats to witnesses that might be called. Your Honor, the rights to bail pending trial is granted in the Constitution. This is clearly articulated under Article 49. It has also been clearly articulated under Section 123, as read together with Section 123A of the Civil Procedure Code. Your Honor, when dealing with matters relating to minors, what must be first considered is the best interest of the child. And what has been articulated, Your Honor, is that as all times when dealing with matters relating to children, what has to be done if the child is not going to be released on bail, then to be remanded is always an aspect of the last resort. So in this case, looking at the nature of the case and the evidence presented by the prosecution, there is the only right thing the court should do is to grant bail to my client. So I have under the bail and bond guideline, they said this, and then you cite a few authorities here and there. Okay, so you bring in the aspect of Article 49, you bring in the aspect of Article 50, look at Section 123 and also Section 123A of the Civil Procedure Code. So all issues relating to bail, they are there. Okay, so that is what I can say on that aspect of the first question. Then also you see there are these questions like review, revision. You see, review is something peculiar because I believe we have talked about it quite some time, by the way, and it is also common during oral exams. So therefore, you have to state the section of the law because it is something that is so common and any panelist would actually expect you to know. So you are actually required to state if it is Order 45 and if it is Section 50. It is the same judge that you apply to for review. You can actually proceed to a certain extent to give those three grounds which enables you to apply for a review. Okay? Because you have to be very cogent when dealing with matters. Because a question like this, you can actually eat like 3 minutes and give sufficient answers. You will make them happy. So review is provided under Section 80 and also under Order 45. Okay, so if you state it that way, you give your definition to that extent and also proceed to give the grounds, then you would have actually answered that question satisfactorily. So on the aspect of revision now, revision come in on that other aspect of supervisory jurisdiction of the High Court that is provided for under the Constitution. Okay, so and in most cases, it is actually in criminal matters. Okay, this revision jurisdiction, it is not there in civil matters. It is only in criminal matters. So the High Court exercises a supervisory role over subordinate courts. Okay, so as part of that role, it may examine the records or orders of subordinate courts and assesses whether those orders are correct, legal, or proper. So it may also review the proceedings of the subordinate court to ensure they meet all procedural requirements. Okay? So, and under the Criminal Procedure Code, it is found under Section 362. So please try to look that up because those questions are really common during oral examinations. Okay? Then on the aspect of investigation of title, you actually get one answer that is on the aspect of searches, whereby under searches, we have three types of searches: the official search, personal search, the historical search. But you have not proceeded to tell me about the pre-contract inquiries and requisitions. Okay? So please look at LSK condition of sale, that is condition 6.5. All right? Then now, I don't know if that was my last question to you. Was it?
Yeah, it was.
It was, huh? All right. So thank you so much. You have really tried. You did well. So I know you will improve. You still have a few more weeks. Just keep reading. That is all I can say for now. So unless if you have a question for me, please proceed.
Not really a question, but a comment. Because this was my first time, and from what I have been inquiring and listening to, people have been telling me, be precise, don't even raise eyebrow so that you don't engage them so much. So those were the reasons why I was not like so direct, like I was not going into procedures because I was avoiding being so much engaged, and then I just get caught up. Yeah, so but I encourage every one of us to read. Don't listen to what we are being advised out there, because we can do better.
All right. Right.
Thank you.
Thank you so much. Actually, if where you have content, please just answer to the best of your knowledge. What you will have to prevent is don't go to Mombasa, don't go to Nakuru, don't go to Juba, and then now come and then give the answer. So it is good to hit the nail on the head. Just be precise, answer the question, but don't go and look around when the mandamano, Baba Mesema, just hit the nail on the head. So you actually did really well. Okay, someone was saying about something about section 3.5. Section 3.5 actually it deals about the aspect of whether it introduces a wife for purposes of succession. Okay, that is one of its major concern. Okay, does it introduce another wife outside the Marriage Act of 2014, pursuant to section 6 and section 9 of that particular act? Does it do that? Okay, so if it doesn't, because that is what is being tested. So your lecturer is saying, no, there is no wife under section 3.5. My lecturer, Anastasia, tells me that there is a wife under section 3.5. Okay? So now, you in an oral examination, so if you are before Mrs. Ruto, so just answer according to what she says. If you are before Anastasia, please don't answer as your lecturer says.
All right. Thank you.
Okay.
Thank you for your feedback.
All right. You're welcome. So now we are going to go quicker. Lual John, please unmute. Daniel will ask you a few questions, and then I will also do the same, and we'll give our feedback.
Yes.
Daniel, take it away.
All right, John. Just before we begin, yes, I want to agree with Angelo and Faith. I think we just spoke. Yes, you should not, the way he's saying, don't go to Juba, go to Khartoum, go to Djibouti, then come back and give the answer. First, before you explain yourself, ensure that you've given the answer. Whatever you are saying is just an addition to the answer. If it's a yes or no question, first start with yes. Then now go into everything. Don't say everything, then finish with yes. It could sometimes the lecturer would think that you're running away from the question. That's why you're beating around the bush. So first, give the answer, then now delve into other things. Give the answer, delve into other things. Is that okay, Philip? There's no harm with that.
All right. Thank
So,
you.
okay. So,
All right.
thank you. John, how are you?
How are you, Mr. Daniel?
I'm well, John.
That's great.
Nice to meet you again, John.
It has been a while.
I'm impressed. Anyway, I just have a few questions for you.
Welcome. Thank you.
Okay. This will be very short. Okay. John, today I want us to talk about a case that I think we've already talked about before. Maybe I asked this time, but I want to ask you again. Do you know anything about the case of Republic versus Mwango?
Republic versus Mwango.
Yes, you talked about. You forgot question. The case of Republic.
Okay. That case, I interact with the case. It is a case that is in the in the ID parade. If I'm not wrong, it deal with about
You mean that,
deal with the ID parade.
John? Do you mean that you could be wrong?
No. I'm sure about it.
Okay, proceed.
Yeah. So it is a case of ID parade that the procedure that's supposed to be followed when conducting the ID parade, and what should be avoided when the ID parade is conducting. So in that case, that's what I can. That is a general issue about the case of Republic versus Mango.
Okay, Faith. Okay, sorry. Okay, John. I think that's very clear. Now, Angelo, your mic is unmuted. Next question. John. I'd like to ask you about the case of DEMA management versus the county government of Mombasa and others. Do you know anything about that case? DEMA management?
DEMA management was the Mombasa County.
Yeah.
Not really, but I will just go and look for that case when we are done. Sorry.
It is fine. It is fine. Now, what are the rules when it comes to ID parade? Let me go back to, I think what you said that you really understand. What are the rules when it comes to ID parade? What are the rules that, we have to ensure that we protect and that we obey when we are conducting an ID parade? Maybe just give me five of the rules.
Okay, thank you. When the ID parade is conducted, the first rule is that the accused person should be informed about the parade. Number two, the accused person, yes, there must be at least 8 people, excluding accused person, and these people must be similar at different aspects, like age and general appearance. Let me just say general appearance, and the ID parade should be conducted in a private place to avoid other people who are not concerned. And number 4, the accused person should just stand wherever he chooses to be. They are not restricted to stand anywhere. They are not supposed to be direct that to stand here or there. They are the one to choose. And also the police officer will not be the one to conduct the ID parade even if he is present. And also the accused person should be asked whether he has a friend to be present during the ID parade. That would be his choice.
Okay.
Thank you.
I think that one we are very clear on. Okay, on to the next question. So person X has appeared before me. I'm a judge and this person has appeared before me. And this person is requesting for bail. They're requesting for bail pending trial. That's what they're requesting for. What are some of the considerations that I need to make before I give this person bail?
Okay, thank you for this question. First of all, for the pending trial bail to be given, there must be things to be put into consideration, and the first of all, it should be yes, the Constitution has granted the bail under Article 50H of the Constitution. So but it is not an absolute. So it must be given when these issues are not in question. Like what should be considered first is if the accused person might be interfering with the witnesses. And I would like to give you the case of Republic versus Lucin injury. So if the accused person is going to interfere with the witnesses, then that bail should not be granted. Also, the gravity of the offense. And I would like to give you the case of Watoro versus Republic. So if that case has the high chances of giving the big or giving the grave punishment, so that it will not be granted a bail. So because easily that accused person might not been going to fear again. He is going to go to the other places. So also the previous record of the accused person should be considered, and the health of the accused person, also the behaviors of the accused person. So these are the things that should be considered when granting a bail, offending bails.
Thank you. My second last question. So someone has come to your chambers and they are requesting for you to explain the salient elements of a contract. What are the salient elements of a contract, John?
Okay, thank you for this question. First of all, the salient element of the contract. For the contract to be said that there is a valid contract, there must be an offer, and that offer must be accepted by the other party. Also, there must be legality. So you cannot enter into the contract which is illegal. Example is like I'm selling a child. So meaning that this is illegal. You cannot sell a child. So it is illegal. So also the consideration, what are the amount to be exchanged for that contract? Like when you are selling a bread, so we know the bread has a certain amount. So what is the amount that is going to be given for that contract? Also, there must be intention. So if there is no any intention, then there is no contract. So like, what are you really want into this contract? So the intention must be there. So I think these are enough. Once one has escaped my mind, but I think there are 5. Thank you.
Okay, John, good work. Now, what is so different with contracts in relation to land? What is so different about contracts in relation to land?
The contract in relation to client.
To land, contracts in relation to land. What is so different about contracts in relation to land as opposed to all other contracts?
Okay. In my understanding, the contract is different to the land, to the contract of land, because when we say contract and we have not included the land, meaning that that contract we can just do it in a just oral contract, but for land, the contract must be doing follow most of the procedures, like the contract of land must be in writing, but for other contract you can just do it orally. This, if I have understood the question well.
Correct. You've understood the question correctly, John. Thank you so much for that. My very, very last question, and if you're not careful, this one might throw you off your feet. So, John, you've heard about the Movable Property Security Act, right? The MPS.
Yes.
You've heard about it, the MPSR Act of 2017, yes?
Yes.
Okay, John, what are the objects of this act? What are the objects of this act?
Okay, thank you. The object of this act, first of all, it is a creation of the security right. So and the perfection of the security right, and also the one of them is there are three. I've forgotten one, but these two are the objective of the MP SARI. Yes, that's what I can say. So the objective is to create the Security Right Act and the perfection, and then there is one. There are three. Kindly just let me just think about it for a while.
Thank you, John. Thank you. Thank you so much. Angelo?
Okay, John.
Yes.
I have two questions for you. Okay.
Okay.
My first question is, what is a derivative action?
Okay. Derivative actions refer to action, refer to the situation of the action that is done in the company regulation or the company management, whereby the majority of the shareholders have a right to bring action against the mismanagement of the majority shareholders in the company. For me, I have the right term to use at the movement, but this is what I can remember because I've read this one for some time back, but you remind me, I will just go and do more about it.
Okay, John. My final question is, name for me or state three types of pleas that you know of. Just state three types of pleas that you know of.
Okay, thank you. We have plea of guilty and plea of not guilty, and silent might be amount to flee to. That's it.
Yeah, that is true. Don't doubt it. So it is called you keep mum.
Keep silent.
Okay, so you can
Yeah.
keep silent. That is also a plea.
Yes.
So Daniel, I can go first. All right. So now, well, John, you really did well today. You tried. So, but also now just give the answer. Please just hit the nail on the head. For example, now when we were talking about derivative action, you actually have an answer. but you have gone around it, and then now you came to it. Okay, so please be precise. Just give the answer as it is. But that is really encouraging, because considering like your first day and today, I can say you have made a significant improvement. So on a derivative action, you have to understand it is one of the exceptions in the case of force versus aborto. Okay, where we have what is known as majoritarian rule. The case of force versus aborto establishes two principles or two rules, whereby the first one is the majoritarian rule, whereby the decisions of the majority shareholders are binding on the minority shareholders. The second rule that the case of force versus aborto establishes is something called proper plaintiff rule. Okay, whereby someone or any bystander or a shareholder cannot allege or claim to bring an action on behalf of the company. The company has a separate legal personality. It can sue and be sued in its own name. So if there is an action that is to be brought by the company or on behalf of the company, that particular legal action must be brought by the company. It is called the proper plaintiff rule. But most of the time, what is examined, it is something called the majoritarian rule. So you have to give that one first, and you can forget. But if you can give that other one, then it is okay. So as an exception now, because you see in law, there are general rule and there are always exceptions there. One of them now being the derivative action, which is a mechanism that allowed shareholders to litigate on behalf of the company. Okay, you can look at section 238 of the Companies Act. So now, then you can also look at the unfair prejudice or these other exceptions. Then on pleas, that one you answered them well, plea of not guilty, plea of guilty. You can also plead something called ultra vires acquit, ultra vires convict, double jeopardy rule. You can actually plead pardon if you have been pardoned by the president. You can also plead jurisdiction. Okay, you can keep mum. All right. So that is it on my end. But sometime if someone asks you about please must read the case of Adan versus Republic. It will really guide you. That is all on my end, unless if you have a question for me, John.
Yes, I have a question, and it is out of our exam.
Hmm.
So now, as a mighty Arsenal, what do you expect in our participation in Champions League? Are we not absolutely going to
No,
carry?
that one we'll do later, please. Okay, leave
Okay.
that one aside. Daniel, please give your feedback. Thank you, Royal John.
Okay, welcome.
Okay, John. John, keep going, keep trying, keep doing your best. The way Angelo has said, the first time we had a communication with you and now, I think the difference is quite huge, John. I like the confidence. I like the fact that you believe in yourself. I like the fact that you keep moving and you keep going. So my encouragement is that just keep going, just keep trying. At least there's a movement. You're doing better. You are doing way better. I'm sure you listen to this recording and listen to the one we had the first day, and you'll see how much there's been an improvement. Now, there's a question I asked about Republic versus Mwango, John. Now, that one you have to. I think now, if you're going to do your research, you'll never ever forget it. So please take your time and read Republic versus Mwango, and you'll be good to go. Another one is Republic versus Adan. Adan versus Republic, I mean, also, that one is also important. Please just do your best and read those two cases. Now, I asked about the Movable Property Security Rights Act, and I think, yes, some of the answers you gave were correct. At least you have an idea about it. But to talk about the objects in particular, they include to promote consistency and certainty in secured financing in relation to movable assets. Then 2, to enhance the ability of individuals and entities to access credit using movable assets. And 3, to establish the registrar and a registry to facilitate registration of security rights in movable assets. So those 3: facilitate registration of securities, enable access to credit using movable properties, ensure consistency and certainty in secured financing in relation to movable assets. So those three would be important. Now, in relation to contracts, I think you explained that correctly. It comes to contracts in relation to land, Section 3.3 of the Law of Contract Act, you got that correctly. They have to be in writing. Maybe you could have added the Land Act, but yes, I think you did well by explaining that. I mean, that's what I was looking for. They have to be in writing. These ones cannot be oral. They have to be in writing. John, do you have any questions for me?
Yeah, sure. I have no questions. So you have been asking people which team do you support. So it is your turn now to tell us.
Okay, which team do I support? Thank you, John.
And don't tell me that you are for Manchester United.
Oh, well, too bad. That was fun, but yeah, that's okay.
Yeah, we are the most enemies in English Premier League.
Nice. All the best, John.
All right, all right. Thank you, Daniel. Thank you, John. We go to our next volunteer. All right, let me check. We have to. Daniel, can you see the hands?
Yeah, we have Were Jacob and someone else. Someone else is you. I think you're raising your hand.
Oh, I have raised my hand. Okay. Okay, where Jacob? Please unmute, sir.
Good evening.
Yes, good evening. So I will have my colleague to first ask you a few questions. Then I will then follow. Okay?
It's okay.
All right. Please, Daniel, proceed.
Jacob, how are you?
I'm fine, Daniel. Good evening.
Good evening, sir.
Yes.
Okay, so I have a few questions for you.
It's okay.
Okay, kindly just introduce yourself again.
My name is Jacobo Rukowere, student number 2023-1087 at the Kenya School of Law, taking the Advocates Training Program. Thank you.
Okay, thank you, Jacob. Now, I don't know if you've been watching the news, but recently we've had a lot of uprising and some very violent demonstrations in France. Could you know what these demonstrations are about and your opinion on the use of demonstrations which sometimes turn into rioting in fighting for our freedoms and rights?
Yes, thank you for the question. The demonstrations in France are all about, first of all, they're about political decisions that are being made based on the refugees and the financial, how do I put it? The decisions that are affecting the lives of refugees mostly in France, and they don't want some decisions. I think one which was touching on, I can't recall it very well, but to something to touch on being secluded, you being treated as a second. I don't know how I'm lacking a word to put it, but now on the right to protesting, I support the right to protest because it's one of the rights that is provided for under the Human Rights, Universal Declaration of Human Rights. It's also provided for under, if in Kenya, the Constitution. But this right must also be protected, and it must be utilized well to ensure that we protect the rights of others who might not be involved in our protests, but might be found in the way of our protest. So they can protest, but maybe they cannot use extra force. So I support the right to protest.
Okay, that's proper. Now, again, on recent matters, recently, the deputy governor of Siaya County, I don't know if that could be a county. I'm just thinking, I'm thinking out loud, but maybe you'll correct me. Now, this deputy governor was recently impeached by the MCAs. Yes, and when this matter came before the Senate, that impeachment was actually revoked. Now, I know in recent past, we've had so many cases of impeachment here, impeachment there, and sometimes most of them have succeeded. What is your opinion in the use of this tool of impeachment in our recent political regime? Could it be that it is being misused? Could it be that it has encouraged corruption in the Senate? What is your opinion?
Thank you, Daniel. The makers of our constitution anticipated checks and balance, and that's why we have separated our arms of government, legislature, executive, and the judiciary. Now, in this case, the governor and the deputy governor fall in the executive wing of the county. However, to ensure checks, then we have them in the county assemblies, where if members of the county feel like they need to provide answers to some decisions that they have made, then they will always be required to come and report. In which case, if the members also feel that they have gone against the Chapter 6 of the Constitution, then in this case, the members will vote on a vote of no confidence. Now, remember very well that also Kenyans can be represented either through the representatives or directly. Represented through the representative means that the MCAs have the mandate to check the governor, the deputy governor, and the executive wing of the county, and also they have the mandate to vote them out if they feel they have done mistakes. Now, at the Senate, the same will happen, where in politics, through the checks and balance, we go with majority rule. As to whether corruption is taking over this decision, corruption is a personal decision. So I think yes, sometimes it might carry out, it might flow and permeate through the decisions. However, I will not look at it keenly, because I think the decision that they're carrying at the Senate and at the County Assembly is a constitutional decision which can be taken. And the deputy governor in this case also had the right to reply, the right to be given fair trial, and the right to respond to everything, the right to present his case, and the decision made then has to be respected. Thank you.
Thank you. Thank you so much. Thank you so much, John. Thank you so much, Jacob. My last question, Jacob, is on the difference between transfer and transmission. This is conveyancing. The difference between transfer and transmission, if there is any difference.
Thank you so much. In conveyancing, transfer means voluntary passing of interests in land from the proprietor to another party. It can be for value or or for love and affection, but it's voluntary passing of land from the proprietor to a third party, who might be the purchaser or might be a friend, a lover, anyone, just voluntary. Now, transmission is involuntary transfer of land from one party to the other, in which case this can happen under, it happens due to the law, where upon death, property passes to the beneficiaries to ensure that the property is continually utilized. Upon bankruptcy, property passes to the creditors through the official receiver. Upon, we can also have it pass through a court decision is made, and the deputy registrar will sign the transfer documents, and the property will pass. Thank you.
Thank you, John. Angelo. Thank you, Jacob. Angelo.
Okay. Jacob, thank you. I have a few questions for you. The first one is, sir, if I may, let's say my recent discussion with John was about police.
Yes.
Let's say someone has been charged with robbery, with violence. Okay, let's say destruction of property in accordance with Maandamano.
Yes.
So now, when this person was taken to court, he refuses to take a plea. So please tell me what happened when an accused person refused to take a plea.
Thank you. When an accused person refuses to take a plea, then in this case, the magistrate first will refuses to take a plea. Okay, in this case, when you refuse to take a plea, remember it is your right to remain silent. So if someone refuses to take a plea, the magistrate will proceed with the case, and this will not mean that the accused is either guilty or not. So the case moves to, the matter moves to wait, just one moment.
Yes, please.
Moves to trial, because now we have to prove whether this person was guilty or not, and the prosecution will now be allowed to move on and present their case.
Okay. Mr. Were,
Yes.
can you please, I'm just wondering, what is the jurisdiction of the Supreme Court in criminal matters?
Jurisdiction of Supreme Court in criminal matters
Yes.
only lies towards interpretation of the Constitution. They don't have jurisdiction on criminal matters, but they have jurisdiction to interpret any constitutional provision that affects the criminal matter. For example, in the Murwa Tetu case, where they had to help in bringing out the issue of the punishment of death.
I'm still confused. I don't know. Maybe I'm wrong, but maybe you can highlight. Please give me the jurisdiction of the Supreme Court.
The jurisdiction of the Supreme Court, first of all, is to listen to appeals that lie from the Court of Appeal. The jurisdiction of the Supreme Court also is to listen to any appeal on matters of public importance. Jurisdiction of the Supreme Court majorly, and which is its major and only jurisdiction, is also listening to presidential election petitions.
Okay, we will come back to that. Okay. So let's say you are Mr. Were Jacob. You are very disappointed in our Deputy President, His Excellency Brigadier. So now you have threatened that you want to kill him. You have made a threat against his life. So can you please tell me, can you be charged with treason in that matter?
No.
No, why?
Because the Constitution allows the right to freedom of expression, in which case this will have to be looked at in terms of, am I capable of doing the same or not? So also,
I've asked you, Were, can you be charged with treason? You have told me no. Then I have asked you why. So it will mean that the answer I'm expecting is that you are going to explain why I cannot be charged with treason, and you will not rely on any other right. So tell me why someone who has threatened a deputy president cannot be charged with treason.
When you threaten a threatening a deputy president, there's, as far as I'm concerned, I've not read a provision in the law where threatening of the deputy president amounts to treason. So in this case, relying on that, and in the thought that this is not a crime that exists currently in the laws of Kenya, then I will not be charged with a crime that, as at the time that it's committed, it's not a criminal offense in Kenya.
Okay. So now, my second last question. Please give me the principle in Denegu versus Stevenson.
Thank you. The principle in Denegu versus Stevenson relies on the issue of it's called why is this name escaping me? Something responsibility. Just one moment.
You're doing well.
It's usually called, that name has escaped my brain now. Whereby someone is supposed to be responsible for something, but they fail due to their act. They are found not to have acted reasonably. The word is escaping me, but I know the provision.
Okay. Then finally, can you please tell me two instances whereby you may not be required to draft a demand letter?
Instances where you might not be required to draft a demand letter.
Yes.
Number one, when you are executing a decree. The other one has escaped me.
Okay. Then no problem, we will still answer. So I can say, Mr. Were, Daniel, I will proceed to give my responses. Huh? So on the aspect of demand letter, there are a few. Okay. When you will not be required to actually draft or maybe serve someone with a demand letter. One of them, it is when you are seeking for Mareva injunction orders. Okay. So I believe you know what a Mareva injunction is, Mr. Were?
Yes.
Very well. So another one is when you are seeking Anton Pillar orders. Okay, because you see, if you serve that particular person that demand letter, maybe he was photocopying, maybe some book that you have written. So you see, the evidence will disappear. So you will need even to go there. You walk around that particular cyber. I know you are a retired cyber assistant, so you go there. Okay, you even buy a book. Okay, like that you collect evidence. So the purpose of that particular order, if you serve them with, let's say, a demand notice, so you see it will be lost. So that is why in those instances, you don't need to write a demand notice. I believe even in divorce petitions, unless if I'm wrong, but yes. So those are it. Then the principle in Dennehy versus Stevenson, it is something called neighbor principle. I have seen someone have written principle of reasonableness. So this one is the locus classicus case when we are talking about negligence. Okay. So you have a duty of care to your neighbor. It will not form part of your bar examinations, but someone will be asked this question in oral. So it establishes the principle known as the neighbor principle. Okay. Then on the aspect of the DP, you have to understand the ingredients of a treason. What is the actors' rules of that particular offense? It is provided under Section 40 of the Penal Code. So you must have threatened, okay, or you have killed or threatened to kill a head of state and government. So there's nowhere that a DP. So if you threaten a DP, unless you will just go to the police station and say that, you know what, Mr. Were is threatening my life, but no one is going to charge you with treason. That is if you have threatened the deputy president of the republic. So the threat must be directed at the president and no one else. So that particular offense is specific. So it does not cut across. So when we are talking about the jurisdiction of the Supreme Court, when you tell me that in criminal matters, so when you told me that it doesn't have that jurisdiction, that position was not correct, because you know the Supreme Court, pursuant to Article 163, that is, if I'm right, So Supreme Court has appellate jurisdiction over criminal matters originating from the Court of Appeal on purely point of law, okay, or something known as significant public interest. I believe in one of your, is it your project work, matter of general public importance, and if it is, unless if it is a matter of general public importance, you see like that one of Moratetu case, it is something that needs to be really, really determined. So there was the Court of Appeal in Mombasa refused to certify a certain matter as a matter of general public importance because someone was saying that people who are accused of murder, where let's say the High Court has original jurisdiction, for example, murder, or in some instances, let's say robbery was violent, so they are being denied their second right of appeal. Because you see, in those, if the Court of Appeal are rendered themselves on a certain particular issue, unless if it is as of right, that is, if it was relating to a constitution, it goes in two ways: a matter of general public importance and an appeal as of right. And if it is as of right, it means that it involves interpretation of the constitution. So things that must have been, let's say, litigated at the superior courts below, that is the Court of Appeal or the High Court, must relate to some Bill of Right or constitution related matters. So that one you will appeal as of right to the Supreme Court. But on the criminal matters or on civil matters, these ordinary matters, it is only when the matter has been satisfied as a matter of general public importance. So now it is now upon you to see when can a matter be said that it is a matter of general public importance. Okay? So, and the jurisdiction of the Supreme Court, it is not one. It is not on the issue of election to the office of the president. There are even three more. Okay? So it is not that one. Please check because I believe there are three or four. For example, they can uh, give opinions like that one that Chief Justice Maraga did when he advised the president to, I don't know if it is that one, but they do give opinions. So the state government agencies, they can apply ministries so that they can advise on a certain matter. So there are about three more or two more you add to that one to the election of the president. Then finally, when someone refuses to take a plea, so there's something said that there's something called deferment of a plea. So it is something that is allowed under a law. Okay? So it is allowed under a law such that now a plea can be taken at a later date. Okay? So when someone has refused to take a plea, then the plea will be deferred to a certain time. It is something that is there. So that is all on my end, unless if you have a question for me. Where?
Oh, okay. I had unmuted. Now, thank you for taking me through it, and thank you. I've learned much today over the same. I don't have any more questions.
Okay, thank you. Daniel, take it away.
Well, Jacob, I think for me, 19, man, 19 or 20. I think you've done very well in answering my questions. I don't think I have any problems. I think you're very articulate, you are very confident, and you answered every question correctly. Now, really, I think anyone who is listening to you now and in the first interaction that we had can really see the difference. I think you've really put in a lot of work, a tremendous amount of work. And I think this goes out to all of us here. If you put in tremendous amount of work, man, this is very, very possible. Just put in the work. We are brilliant, 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 brilliant people. We just put in the work. We just couple it with the reading and studying, and we will be good to go. And I mean, look at where now, man. You've done so well. Now, I know the questions I've asked you are based on the recent issues happening in this in this country and outside this country, and really I think I'm also very impressed by how much you've kept abreast of these things. What's happening in France, what's happening here, what is very, very important. And I think your answer on what's happening in France is is proper. I asked about impeachment, and you got that correctly. And no, I asked about your opinions again. You say what your opinion is. You don't have to say what I think is right or what I think is wrong. And yeah, I think for me, I don't know which question did I ask you last. What was my last question, Were?
The question from Makwe has really thrown me, so has shaked me, so can't remember the last one.
Yeah, but I think, yeah, I can say that you got my questions correctly. So, man, all the best. Keep going. Keep pushing, man.
Thank you, Daniel. I keep listening to that first one.
That you see the corrections that you need to make here, but I know we've come from somewhere. But all the best, man. I like the way you've put in the work. Just keep pushing, man.
Thank you.
Okay. Thank you, Daniel. Thank you, Were. Don't be afraid. Okay. Maybe next time I will be nicer to you. Anyway, who is our next volunteer? Time is now really running. Please raise your hand. Tusonge mbele pamoja kama Jubilee. Yes, Chepkirui Amy, government. Yes, Chepkirui, please unmute.
Thank you.
Okay, and we have Lim Thomas. Daniel, meanwhile, you can take note of the people who have raised the hand. I believe I have more now.
Okay, so it's Chepkirui and
then Lim, then Akumu Onyango. They will come in that order.
All right.
Yes. So, Chepkirui, let me call you. Yes, let me say Amy. Okay. Right.
Thank you.
In case
I want to have my first try today, then I see the subsequent ones, how they'll be.
Okay. So, are you ready for your orals?
Not quite, but I think from what I've had my colleagues go through, I think there are questions that we've interacted with, like things that we've interacted with, but then I think we don't give that deep thought to. Like there are things we know, but we are not careful. We think we do not know, or we do not expound as you are telling one of us, or maybe we know them in part and we do not know the rest of the answers. Yeah, so that's why I just want to give a try. However, I'll perform. I think I'll be more prepared maybe in the second one.
Okay. That is nice. That is nice. I believe you will do well. So my first question to you is, are you aware of any big activity in the sports sector in the Republic of Kenya that happened today? Anything that can come of your mind?
There was an event at Nyayo Stadium by Athletics Kenya, I think, and they were coming up with a team to represent Kenya in, I think, under 20. Was it under 20 or a team that would represent Kenya in some athletic competition that is done internationally?
Okay.
Thank you.
Very well. So can you please tell me any one court or the only court that is a creation of a statute that does not have any constitutional underpinning?
Thank you for the question. I think the small claims court, is.
You think?
Sorry?
You think you are not sure? I don't know if you are answering the question.
the small claims court. Let me say the small claims court in the affirmative, and but allow me to say I stand to be corrected.
Okay, okay. Can you please tell me, how do you refer to people who handle these matters at the small claims court? We know we have, let's say, it is a magistrate court, we have magistrates, we have judges, okay, we have justices. Who handle these matters at the small claims court?
The allow me to say the deputy registrars, the DR, or it's not a magistrate court per se.
How do you now call that person who listen to these matters?
I think they are.
You have used the word, I think.
Yeah, they are not deputy registrars because adjudicators or they are not magistrates. Adjudicators or some. Allow me to say adjudicators, but I stand to be corrected again.
All right. Please give me, differentiate for me between murder and manslaughter.
Murder is one of the serious crimes in the penal code and in the criminal litigation, and allow me to just say generally, manslaughter. In manslaughter, the penal code prescribes that one is jailed for 7 years, but in murder you are jailed for life. You're given life imprisonment upon being convicted guilty of murder, and upon being convicted of guilty of manslaughter, the penal code stipulates a sentence of 7 to 14 years. In manslaughter is a kind of.
Let me put it this way, Amy.
Yes.
And if we agree or disagree, then you can tell me. In manslaughter and in murder, do you agree with me that a person must have died in both circumstances?
I agree that in both cases,
there is loss of life.
Yes, there is loss of life.
So if there is loss of life in both circumstances, what then distinguishes one from the other? What is the distinction when now a court will say that you can slaughter, or the court will say that we convict this person with murder? What is that distinguishing factor? It has nothing to do with sentencing, because manslaughter, you can sentence a person 1 day to life imprisonment. For murder, you can sentence a person to life and also death. So, but there is a distinguishing factor between these two. What then distinguishes one from the other? We agree that there is loss of life. What then is the difference between the two?
Thank you. I believe it's because for such serious cases, there has to be proof of actus reus and mens rea, and among other elements. And in the case of murder, there has to be proved actus reus and mens rea, and that directly links the accused, and of course the causation would have occurred. When we come to manslaughter, the accused is directly linked to the cause of death, but then it is hard to prove that the actus reus and mens rea do not link him or her directly to the death, but then they are linked to the cause of death. So in the absence of mens rea and actus reus, that's where now they are charged with manslaughter.
Okay. Okay. Please differentiate for me res ipsa, liquito. Okay, it depends on where you took your first water. In my village, we say that way. And contributory negligence.
And contributory negligence.
Yes, res ipsa, loquita, or liquito, whichever, and contributory negligence.
Res ipsa loquitur or loquita is a principle, I think a principle in tort that after you're held with strict liability to a negligence that is caused, that you cause directly or indirectly, and it is a principle that was established in the case of sorry, I'm forgetting this case law, but it's one of the landmark cases. When you come to please pardon me, you said receipts allocation and which one?
Contributory negligence.
Contributory negligence is whereby, for example, allow me to give this analogy, where, for example, in a case of accident, you as a driver was not drunk, you were not necessarily speeding, but you maybe inadvertently caused an accident to someone who appeared in a corner that you had not seen, and you ended up hitting them. And in this case, when you talk about that pedestrian who just maybe tried to cross the road without maybe looking right and looking left, playing a part of your responsibility, if this person, like for example, takes the driver to court, they will also have a part of where they have contributed, like the negligence on their part. Like they should have looked right and left, and if there's a vehicle coming, you wait for it to pass. But the fact that they did not wait, whether the driver was speeding or not, there is an aspect that this person has contributed in that accident that has occurred. The other one is about strict liability, and it is a principle that was established in a case that I have forgotten.
Okay, thank you. That is all for me. Daniel, take it away.
Thank you. Amy, I just have a few questions.
Yes.
Yeah, now I've realized that Angelo has referred to you as government. What do you have to say about that?
Angelo. Sorry.
Yeah, the person who just asked you a few questions.
Has referred to me as a government.
As government.
I'm not sure whether I'm getting the question, but if I've been referred to as a government, it's because of the government is made up of the people of Kenya, and me being a Kenyan, I form part of the government because there's no government without the people. And the first, in the preamble of the Constitution, it says we the people, like the power is government is power, and the power is us. So and taking cognizance of the preamble of the Constitution, I'm part of the government. If I got your question right.
So you want to believe it's nothing to do with your name? Because I think from my observation, it's the first time he has used that name.
No. It has nothing to do. I'm not. I think no. I'm Amy Chepkirui and a student, and I do not work with the government or represent the government in any way. Sorry, I don't know whether I'm getting your question. Sorry.
All right. It's just a tangent, nothing serious. Anyway, now let's get into the real questions. Do you mind maybe just mentioning the pre-litigation preliminary considerations before you go to court and file a suit? What are some of the things that you would consider before you even start drafting that pleading? What are some of the pre-litigation considerations that you make?
Okay, thank you. I would consider the parties to that suit and know who's the plaintiff, who's the defendant. If it's a case of claims, who's the claimant, who's the defendant. It's a case in the Court of Appeal that have been given, who's the appellant, who's the respondent. I would also consider the jurisdiction of the court that the jurisdiction in that matter, or like what the matter is about, the course of action. And then now, afterwards, I now consider the jurisdiction. Which court are we best suited to, is best suited to handle this matter? So parties to the suit, claim, course of action, jurisdiction, and another thing that I would consider is, I think, feasibility of that case, because there are cases where, for example, the plaintiff has come or the claimant has come and they are seeking to get a claim of, say, 800 shillings or 8,000 shillings. And by approaching the court, you are likely to even spend more than that. Then I think it would not be feasible in my view. So I would look at the feasibility. I would also consider, I think, the conflict of interests, so that I'm not conflicted as an advocate. That is all I can state for now.
All right. That's fine. Do you know anything about review?
What I can say about review is it is a remedy as provided for in article it's an article in the Constitution that provides review as a remedy, where if in the course of the litigation of your matter, there are some facts of law or some procedures that were not followed properly, and you feel that is what caused you to the case to come out in adversely, like you did, it's like injured the outcome injured your client. You can go for review on those grounds, and it is upon the court's discretion, and the High Court for that matter, not any other court, to allow you to give you the review and to review your matter before you can maybe take it for appeal, if at all the review would not be allowed.
Can you apply for both review and appeal?
I would say that you do not apply for them concurrently, but you can apply for review first. And then if it is not allowed, you can now proceed to apply for appeal, because now appeal will go to the Court of Appeal, which is a court that is higher in rank to High Court. But the review is done within the High Court. Your matter was previously in the High Court, and it is reviewed in the same court, the High Court. Appeal will go to the Court of Appeal. So in my view, you would first wait to see if the review will go through. If it will not, it will not be allowed, then you can proceed to the Court of Appeal and appeal for that matter.
What are the grounds for review?
The grounds for review are if you as an advocate feel like the procedures were not followed like you are not given fair hearing during in the course of the matter, or you feel like according to having gone through the judgment, you feel like the judge erred in law. You can appeal on those grounds. On issues of law, issues of procedures, and like not being given fair hearing.
Okay. Do you know anything about the MPSR Act?
A little.
What is it about? What does it regulate?
It regulates the security rights and the security rights and generally if there are cases involving small, let me call them small lenders and small like credit facilities not involving security rights that are not necessarily of a lot of value, like millions of money, for example. First kindly.
All right. Now I'm going to ask you questions in relation to the same. Now, there are certain things that the MPSR Act does not apply to. Which are these?
I think
You think, or you
immovable property like land, because other movable property like vehicles can be apply, but immovable property, in my view, do not apply, because those ones, in my view, would be charged, and those ones would involve other institutions.
Okay, my last question. Is there any difference between a charge and a debenture?
There's a difference between a charge and a debenture. A debenture is a special liability. A charge is created when a property is used to secure credit. Say a piece of land, you've approached a bank to be extended to say 30 million, and the property is worth 30 million or more. You charge it. So a charge is created after being extended the credit facility. A debenture is mainly on the shares. It involves shares, and I do not know how to explain it, but allow me to end it by saying that it just involves shares. It has nothing to do with the immovable property. Thank you.
All right, thank you, Amy. That's all from me. Angelo, can I give my? I hope you don't mind if.
Yes, you can do quickly.
All right.
Yeah,
So
28 minutes, and we have like 3 more volunteers.
yep. So Amy, please, since I'm supposed to reply very quickly, please try and read on review. Now you said this can only go to the High Court. Please try and read on review. I asked you whether you can review and again appeal. I think you said if you don't do them simultaneously, then that's okay. Now, whether that answer is right or not, I do not know. Whether it falls under abuse of the court process, I do not know. Anyway, what I'm trying to say is just please, after this session, try and read on review, and I believe that you'll be good to go. Now, grounds for review: discovery of new and important matter or evidence. We have mistake or error apparent on the face of the record, and any other sufficient reason. Now, I asked you about pre-litigation. Pre-litigation consideration, and I think you talked about course of action, possibility or reasonability of the this suit, the ability to fund it, and whether the court that you need to go to, jurisdiction, and everything. Of course, the whatever the right documents to draft and everything. I think that was an easy one, and I think that one you did well. I also asked about the MPSR Act, whether you know what it's about. Now, MPSR Act regulates transactions in relation to movable properties. Yeah, it regulates movable properties. So I asked you about things that it doesn't apply to. You talked about the movable property, which is okay. But please, I'd also like to invite you to look at the Act and try and then consider Section 4 of the Act. In Section 4 of the Act, you'll find that it's written that the MPSR Act does not apply to one, a security right in book entry securities under the Central Depositories Act. Now you said it applies to shares. Again, please look into that. Then I think you said it doesn't apply to. It might applies to one of the two. Then two, the creation of lease or transfer of an interest in land. I think you talked about that. Then three, a security right in a vessel, including a mortgage right, subject to the Merchant Shipping Act. Number four, a security right in an aircraft, subject to the Civil Aviation Act. Number five, a lien charge or other interest created by law. So please just look at those few things and you'll be fine. Now I've realized, Amy, that you haven't really gone through the MPSR Act. Please just take your time and do that. I think it's something that they ask, many lecturers ask about it. Please just try and go through the Act, and I believe that you'll be good to go. Any questions for me?
Thank you very much. Yeah, I haven't really gone through the MPSR Act, so I will really do that. I've learned a lot from your questions, and I endeavor to delve into the details of those ones, like the review and the processes thereabout, and the MPSR and the rest. Thank you.
Nice. Now I know this was the first session, and that's how it feels. That's how it feels, Amy. That's how it feels. This is the first step. It's that first big step. So from now moving on, at least it will be written that you've gone through this. Now you know yourself, you know what you need to work on, you know the kind of pressure that is experienced during these circumstances. So I want to believe that you'll continue learning how to balance that. So this was a very, very big step. All the best, Amy.
Excuse Daniel. Daniel, before
Yes.
the next speaker, the floating charge and the debenture, the last question, please.
I know I asked her about the difference between a debenture and a charge. Of course, a charge is on immovable properties. A debenture covers both movable and immovable. Just that a debenture is a liability. We have given you a loan, and you're registering a debenture on all assets of the company, which is fixed and floating, or when it is fixed, it's a debenture on a particular property that you own. There's really nothing much about it. Does that answer you, Nicholas? Of course, the charge is on land, yeah? I think that is very clear. So I just wanted to make that difference. Yeah.
Yeah, thank you very much.
Debentures of the assets of the company could be fixed or could be floating. Angelo, go ahead.
Yes, Amy, I'm also going to be quick in giving my review. So what I noticed that while I also appreciate the fact that you have volunteered today and it was indeed your first time, I would say you tried. The only issue is that you are doubting yourself a lot, even the things that you are sure you know, but you would use the word you think. So if you think, so it will mean that you are not sure about what you are saying, and most of the time the panelists are not happy when you are in a state of disbelief or when you don't believe in yourself or what you are saying. So please mind that one and ensure that you maintain your ground. Okay. For example, the small claims court, you really know that it is the only court, to the best of my knowledge, that is a creation of a statute. Because if you look at the ELC code, it has a constitutional underpinning. The same with the ELRC, it has a constitutional underpinning. But this particular specific code, so it was established in 2012. So yes, that was something that you know. And then at the same time, there are adjudicators. Okay, they are known as adjudicators, the people who sit or who handle those matters. The distinguishing factor between murder and manslaughter is something called malice aforethought. You see, you are actually right when you are talking about actors' rules and mens rea. So you realize that the only missing element in manslaughter is the mens rea. You did not have an intention to kill this person. Okay? Me and my 10th P tumekosana for one reason or the other. I don't know, amenigonga na mwiko, huyo nimeenda. Okay? So in those circumstances, maybe she did not intend to kill me. Okay? But anyway, nimeenda. So there are things that can happen. Maybe it was insanity, provocation. Now those defenses will come and defeat. Because most of the time, when the death of the person is not disputed or it is known, like most cases that happen whereby the families, they kill themselves because of a loaf of bread, you see. So now what is the defense that you are offering? Say that if the defense is going to succeed, then murder is going to be reduced to manslaughter. So if you look at section 203 as read together with 204, so you will see the aspect of malice aforethought. Okay. Then on the aspect of the res ipsa, that one you answered well. It is just that you are trying to bring in the case of Rylance versus Fletcher, which was, yes, I would say not okay, because you would just tell me that res ipsa loquita or something like that. It just means that the thing speaks for itself, so you don't have to bring some extrinsic factors for you to explain a thing. But on the part of contributory negligence, it means that this is where the plaintiff, okay, is actually did not or failed to exercise something we call reasonable care for their safety. You use an example of an accident. Okay, so where the plaintiff has failed to exercise reasonable care of their safety, then they have contributed to that particular accident. So I believe my questions, those were my questions, unless if you have a question for me.
I am so grateful for the opportunity, and I must say I have learned a lot, and I think I'll be better off next time. Thank you very much.
Okay, thank you. So now I believe Daniel, we will try to hear all the three volunteers. So we'll go first. Is it Lim Lim? and then Akumu, and then another one. So we'll try to squeeze like 7 minutes each, because we are now, we are at 22:41. So let's see what we can do. So Limlim, please unmute.
Yes. Yes,
Angela.
I'm already unmuted.
Yes, Daniel.
I'm thinking that we do one each so that we move fast.
Okay.
We can ask maybe 3 quick questions. Yeah.
All
Okay,
right.
so I'll take Lim, then you'll take the next person, then I'll finish. Okay, Lim, how are you?
Fine, thank you, Daniel.
Nice to have you again, man.
Thank you. Equally
All right.
pleased.
Okay, so of course I would ask you to introduce yourself, because I think you've been with us for a while. Now I'll just ask you a few questions, very, very, very quick. Lim, do you know the case of Ditidobi and Company Limited versus Mushina? Ditidobi and Company Limited versus Mushina?
I have read it. I read it quite back, but I can't remember the facts.
Okay, it's on striking out of suits. So maybe that can refresh your memory.
Come up again. It was striking out of suit.
It is on striking out of suits. Do you remember anything about it?
No, but I can explain what striking out of suit is. But I
Please do that.
I don't remember. Yeah. Okay. Striking out of suit is I would call it a power exercise by court when the matter before it is founded on the grounds that are fictitious. They can okay, it can be I mean that word. Also that the grounds may be lacking, that ground lacks the legal backing. It's intended to kind of bring embarrassment to the court. Yeah, such circumstances will call the court to strike out the suit. Yeah.
All right.
Or it can be a point. It can be a ground for objection to a suit.
All right. What's a preliminary objection? And a case, please.
Preliminary objection is anchored. Is one. Okay, it's one of the methods that are used to respond to is it a pleading or a suit? I think a pleading, to respond to a pleading, and it is provided under Order 51, and it is founded on the case, but the most cited case is I think Mukisa Manufacturing Biscuit or Biscuit Man versus Western End Distributors.
Okay, that's correct. It's on point of. You said it's on point of what?
I said it's one way of preliminary objection is one way of it's among the 3 ways actually under Rule I think 14 of Order 51 of responding to I think it is responding to a pleading or a suit. I can't. But it's one is preliminary objection. The other one is I think raising grounds of opposition, and then the third one is the third one. But that is what I can remember. It's just gone off my mind now.
Okay. What's Ganishi proceeding?
Wow. I am conversant with that word, but right now I can't really. I'm not. I will check after I leave this place, but I am conversant with Ganshi. That word, I'm conversant with it.
What's an application for Anton Pillar orders?
Yeah, these are. I think now I can. You have kind of refreshed my mind. it is related to Ganshi, and this is it's I will call it a freezing order, whereby you want to ambush the other party so that you can get the evidence or the documents that will help you prove a fact in issue.
Mareva injunction.
It's related to what I have. It's related. It's a relative of, if I may use that word, of Anton Filler. So they are more or less the same thing when you. Yeah, they are more or less the same thing.
Right. Interpleader.
Yeah, interpleader is it is provided under Order 34, and this is whereby you have that you have a person here who can call the person a third party, so to speak. He comes to the court so that because he is in possession of a property, for example, a car, and he or she does not know who the proper owner is among the parties who are before the court. So he's coming to ask the court to determine among the contesting parties who is the rightful owner or the lawful owner of that particular property, so that he can give the property and also claim his bargain, whether payment or his interest. He or she can claim his interest from the rightful owner of that property once the court makes the determination.
Okay. Let me give my reply. And Lim. Now, the reason why I kept shooting these questions at you is because I realized that it's a weakness. So please try your best and look at the types of interlocutory applications. Striking out, you got that correctly. The grounds are no reasonable cause of action. The application is scandalous, frivolous, and vexatious. It's prejudicial, an embarrassment or delay of the fair trial. It's an abuse of the process of the court. On those bases, on those grounds, you can make an application to strike out a suit. Now, I have shared this case of DT Dobby and Company Limited versus Mushina 1982. I have shared it in the group. We've talked about it. We've talked about Narita Karimi Njeru. I'm just asking this because I was just confirming if really you took it, your class took it seriously and they looked at it. Now, in this case, it was decided that no suit ought to be summarily dismissed unless it appears so hopeless that it plainly and obviously discloses no reasonable course of action, and it is so weak as to be beyond redemption and incurable by an amendment. Meaning you cannot just summarily dismiss, or you cannot just strike out suits unless it is very hopeless, or even an amendment would not help that particular suit. So this is in relation to the Narita Karimi Jeru case, which I know probably you know what it talks about in relation to striking out suits on the basis of precision. With Mareva injunction, you said it's the same as Anton Pillar, but I want to disagree with you. It's under Order 39. It's a suit other than, it's a suit for recovery of immovable property with or without rent or profits, or for, partitioning of immovable property. So we also have Anton Pillar, which is the granting of the right to search. These two are different. The reason why I'm saying this is just go through your notes and you'll see the difference. There's a difference between Mareva injunction. There's a difference between Anton Pillar. Now, Anton Pillar is the one that we can call the one which gives you the right to search, the one which Angelo was talking about. You're going to search someone's property, you're going to take inventory, you're going to seize evidence the way you said, and in this circumstance, if you give someone a demand notice, then of course they'll hide this away and you'll not be able to find it. Mareva is where this person is moving a particular property which could be attached from the jurisdiction of the court, and you're going to court to ask them. Probably you have a decree already, or you are just about to get a decree to ask them to, actually attach that particular property, or for them to show cause as to, So this one is in relation to property, but this other one is in relation to such. Then I asked you about Mareva, sometimes they talk about the people who compare it with an arrest warrant. Then Anton Pillar, the people who compare it with such warrant. So just you can use those ones also to differentiate the two. I'm just trying to go through this real quick because I think Angelo also has a few people. Now I asked about interpleader, you got that correctly. I don't think I asked about anything else that maybe we can. I asked about Ganishi proceedings. And again, you confused this with Anton Pila and all that. So Ganishi is where someone has money in a particular court, and of course you have a decree, for example, against this person. And one of the ways that you can do this is, of course, by attaching that particular money in that particular court. So you make an application to the court so that money can be attached. Then the court will give a Ganishi order to that particular court not to use that money, not to allow that money to be taken by this particular person. And that money will be sent to you, of course, if it is in that particular bank and the bank has no interest in that particular money. Then when you're talking about the pleader, you talked about the fact that this person still needs to be paid. I don't think that's the case. It must be that you are ready to dispose this property. There is no collusion, and you have no interest in this property whatsoever. So again, what I'm trying to say is this: just go and try and look at the types of interlocutory applications, and you'll be good to go. Them. Okay? Probably there's a reason as to why we've done this today, just so that you can refresh your memory and be very, very sure in relation to these ones. That's okay, Lim?
Yeah, thank you.
Welcome. Angelo?
Okay, I'm going to go quickly. Akumu, please unmute. We are live in 7 minutes.
I have unmuted.
Okay. Thank you. So, Akumu, are you aware of the recent decision of the High Court in the CAS matter?
Yes, I am.
Can you please state for me 3 final orders that were made by the court?
So in this case, there were orders that were made by the court. First of all, the court decided on the issue of jurisdiction, where the court opined that the matter was rightfully before the court, since the respondent was alleging that since it was a matter of appointment, then it was to be filed at the Employment and Labor Relations Court, but then the High Court, upon considering the submissions by both parties, came to a decision that it was rightfully before the court. Another issue that the court decided on was on public participation, where the High Court opined that considering that the additional 27 CASs were appointed without public participation, then the appointments were null and void. So the court reached the decision that the first 22 or 23 CASs, they were rightfully appointed, taking into consideration public participation, but then the others were not rightfully appointed. So another issue that the court decided on was whether the president, for lack of a better term, I will say whether the president acted in excess of powers when he went out to appoint the CASs. So the relevant law that deals with chief administrative servants envisions only 22, is it 22 or 23 CAS to be appointed, but then the president went on and appointed a further 27. So The court on that issue ruled that indeed the president acted in excess of power. So those are the three issues that I can talk of at the moment.
Okay, thank you. Thank you, Akumu. Have you managed by any chance to read through the petition challenging the Finance Act filed by the Honorable Senator of Busia, Okia Mtata?
I haven't followed the proceedings, but I've seen them, but I haven't gone through the petition yet.
I've not gone through the petition.
Yes.
Okay, very well. So now, Mr. Akumu, please define for me a separation policy.
So a separation policy, these are the policies that are incorporated in an organization or a firm to deal with employees whom I'll say they are leaving or they intend to leave the organization. So some of the activities that can be found under a separation policy will be retirement. You can talk of resignation, and you can also talk of summary dismissals. It's basically the policy that has been put by an organization or a firm to deal with instances where employees will leave the firm or will cut ties with the firm. Thank you.
Very good. So now, please tell me, what are the qualities of a good separation policy?
So the qualities of a good separation policy would be, one of them will be, they will take into consideration the aspect of, I would say, public participation, and in this case, public, I will be referring to the employees in the firm, so that they will be actively involved, let's say, in coming up with a proper separation policy, so that the policy reflects on the needs of the organization. So we'll talk of one that is inclusive. I'll also talk of one that is promotes the value of equality, so that I'll give an example of summary dismissal. If then an organization opts to summary dismiss employees based on these certain grounds, then it should cut across all employees, so that it is not discriminating against the employees of the organization. And then, so those are the two reflections of a good separation policy that I can talk of at the moment.
Okay, that is well noted. Finally, and this one, please, under 30 seconds or even less, what is the difference between an ordinary resolution and a special resolution?
So a special resolution is made by a company by more than 75% of the people who are making the decision. So it will be, an example will be, maybe it's a decision rendered by the directors. Then if 75% of the directors render the decision, then it will be a special resolution. On the other hand, an ordinary resolution, it's basically a simple majority that talks of 50 plus 1%, such that if 50 plus 1% of the members of a company.
Did we just say 50 plus 1?
Yeah, 50 plus 1%, just a simple majority.
Are you sure about that?
Yes, I am.
Okay, all right. Well, such that we have one more person, and it is now 2300 hours. So you answered well about the aspect of the CAS's case, because these are some of the things that will be coming up a lot during your orals. Any current matter that is going on of national importance, for example, the Finance Act, you actually need to read that one, because by the way, it is well drafted, plain English. Like, I really like how it has been drafted. And there are questions, even the replying affidavit of the Senate Speaker. Okay, So please look at that particular petition and look at the responses there too. Then on the aspect of separation policy, I'm surprised you actually answered it well, because this is something that you'll be taught later, or you have been taught already. So you really answered it well. It is just on the aspect of the qualities of a good separation policy, which it must be amicable, which means that it has amicable means of separation. It must have notice, it must be consistent, so you don't have to decide one policy for a category of people and another policy for other category. Okay, so the procedure should be clear. There's something called equality, okay, and it is easy to implement. So the aspect of ordinary board resolution, you have said 50+1, that applies to the election of the president, okay? But a simple majority is 51%. It is not 50+1, but a simple majority is 51%, okay? A special majority is 75%. So sometimes you can say a 2/3 majority, okay? And then the other one you say simple majority, such that simple majority is 51%, 2/3 majority is 75%. So I would say you really did well, Akumu. Just keep it up. Just keep reading. Hit the nail on the head. You have not gone to Mombasa. Maybe you have never gone to Mombasa, but in this matter, you have not gone to Mombasa. Okay? So that was really, really, really good. So our last person, Daniel, was who? Said that we can take like 2 minutes.
Last person, please avail yourself. Last person, please avail yourself. Yes, it is Oscar. Oscar?
Yes.
How are you, Oscar?
I'm good. How are you?
I'm well. A few quick questions. Okay, and so we begin. Differentiate between joint tenancy and tenancy in common.
Right. So joint tenancy is a concurrent form of ownership in which the tenants therein have an undivided interest in the property. And upon death of one of the tenants, the property devolves upon the surviving tenant. But for tenancy in common, it's also a concurrent form of ownership in which the tenants there to hold property. They may hold property that is unequal, that ownership, and if one of them dies, the property does not devolve to the remaining or the surviving tenants, but it goes, or it devolves under the laws of succession.
Who are the current judges? Who are the current judges for the Supreme Court?
We have the Chief Justice, Honorable Lady Justice Koome. We have DCJ Mwilu. We have Ouko, Wanjala, and Njoki Ndung'u, Smoking Wanjala. Wait, I've said Wanjala. And then we have Lenaola.
You're sure you would like to call them like that in court?
I wouldn't. I'm doing that in the interest of time. But obviously, I wouldn't do that in court.
How would you refer to them as?
Right, my lords. Okay, we have my lord, my lady, the Chief Justice, Lady Justice Koome. We have my lady, the Deputy Chief Justice, Lady Justice Mwilu. We have Justice Lenaola, Justice Ouko, Lady Justice Njoki Ndung'u. We have Honorable Justice Smoking Wanjala. Who else am I forgetting? And Honorable Justice Ibrahim.
What's the quorum of the Supreme Court?
5 judges of the Supreme Court.
Okay. What are the elements of adverse possession?
Well, elements of adverse possession have been set out in the case of Mombasa Teachers should be college. I can't remember the other party, But the first one is that the claimant, the one that is claiming adverse possession, must have stayed on the piece of land for at least 12 years, and that stay must have been uninterrupted stay, and that stay must have been obvious and notorious, so that then this person must have stayed on that piece of land without hiding. They must have stayed there when everybody else knows that it's this person that is staying on that piece of land. And then the fourth one that I can think of is that this person must have not been given consent to stay on that piece of land by the owner.
So no consent.
Yes.
Last question. What's the induplam rule?
Right. So the induplam rule in our laws, it's under section 44 of the Banking Act, and it's to the effect that if a creditor or a loan, right, I mean a bank, has advanced a loan to you, that bank or that creditor should not charge you interest that is more than the amount of the principal, as at the time when the loan becomes non-performing. Something else on that rule is that microfinance institutions that are non-deposit taking are not bound by the rule in Duplam.
All right, that's all. That's all for me. In Duplam, I think that one you've joint tenancy and tenancy in common. That one is okay. Elements for adverse possession. Please confirm whether you said that there must be consent. Please check that again, because from
I said there must not be. I said there must not be consent.
Okay, sawa. But it should be neither by force nor secretly, yeah? Correct?
Yes.
Okay, then we are okay with the adverse possession. I also asked you about the judges. Okay, that's fine. Okay, I think you answered all my questions correctly. Do you have a question for me?
I do not have any question for you. Thank you.
Okay, very well. That was a very good session, Oscar. All the very, very, very best. Good job, man.
Thank you, Senior.
Okay, Angelo, would you like to go first? Then I close.
Yes. What I can say is that the session was really, really great. People did really well. So, and this is what we have been hoping for, because it can really clearly tell that you guys are studying. It is giving us energy. We'll continue to pray for you, because once you have passed your orals, and then God will do the magic in your project work, then you passing the bar is almost guaranteed. So please, let's keep working us. Let's keep studying smart, not just hard, usikose usingizi, but please keep it up. That is what I can say. So Daniel, take it away.
Okay, guys. So here we go again. I think we had a very good session today. If you haven't realized, or if you realized, today we were a bit very, very strict. We were a bit very, very serious, because again, we are moving to the next level now. This is the 9th session, meaning we've been practicing, and we need to get better. And I think you guys were able to sustain that. So please, we keep doing our best to ensure that we are moving. There's some progress. So if maybe Angela was too harsh to you, or I was too harsh to you, we apologize. No malice at all, no malice aforethought. So it wouldn't be murder anywhere. But yeah, what I'm trying to say is, for us to improve, sometimes we really have to go through tough times. We really have to be tough. But yes, good thing is you guys are studying and we are doing well. We will continue to try our best to balance it. But of course, we want to try our best to also push you guys to ensure that you guys are growing and you guys are doing well. Now, when it comes to orals, I think one thing that you guys have realized, it's like talking in class for the first time. The first time you do it, probably you're scared. Probably you're thinking about everyone. Probably you think everyone is looking at you. Then the next time, again, you're doing it, you're a bit scared. Then the third time, then the fourth time, then it just becomes a habit. You just keep doing it and you don't even think about anything. You don't even feel about anything. Now, that is one of the reasons why we have this platform, to help you grow that agility, to help you progress when it comes to how you can answer these questions, however quick they come. So please, again, I'd just like to encourage us, let's use this platform for that. You can make all the mistakes here and they won't mean anything. Yes, maybe you have a friend who is listening, but if they hear you making a mistake today, then what? What if they're just quiet and they've never made any mistake? What if they're not learning? What if they're not pushing themselves, but you are? So when it comes to this session, it's about you. Just try your best. Let's use this platform to grow. Just say something. At least before we finish this session, let it be that even once you said something, you tried at one point. Again, I've said it's like speaking in class. The first time you do it, or speaking in public, the first time you do it, you're scared. The second time, you're not so scared. Then as you continue to do it, it becomes a habit and everything just gets very, very easy. So please, I'm pushing all of us. Let's not have the same people every day. Let's have new people as we continue to move towards orals. This will help you. Just volunteer and you'll see the difference. You'll see the magic. Where they will tell you the same, Lim would tell you the same. Probably right now when Lim is unmuting, he's not even thinking about anyone. He's just unmuting freely and just saying whatever comes to his mind because he has built that agility. So please, 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 let's do that. We are here for you. We are here to help. We are here to grow together. There are things that I'm learning from you, and I believe there are things that you're learning from us. I continue to wish you guys all the very, very best. When it comes to your project, please just ensure that you're doing your best. Guys, orals and project work really, really, really matter. So please don't take it lightly. Please just try and put in all the energy that you can. Again, please also try to create time to just relax, to mellow out so that you're also able to balance. There's no need to go mad, to go crazy, to really, really lose your mind and everything. Try also to find some time to just relax your mind, to have your own time to blow off some steam, then get back to it. I think it is very, very important. So I would also like to encourage us to find a way to blow off some steam, find a way to also work on your mental health, which is very, 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 very important. Again, if I was too harsh today, we apologize. But again, we're only trying to push you to the next level. If Angelo was too harsh today, I think I want to apologize on his behalf. He will pay my fees later. But I think I'd also like to apologize on his behalf. We are just trying to push you to the next level. I hope that this was helpful. I hope that we learned again today. And I can't wait for us to have another session next time. Now, I record these sessions. I hope no one has a problem. I know we have privacy issues. We have personal information, personal content issues. Please, the YouTube channel where I put them, it's not for any commercial, gain. I'm not gaining anything. I just want to put them in a place where all of you are able to access it. Okay, so please, I'm recording it not for any financial gain, just to ensure that everyone is able to access it and everyone is able to learn. So please don't sue me anywhere, please. I hope that by dint of you guys being in the meeting, that is acceptance, and you guys are allowing us to use your information for the purposes of education, and I hope that's okay. I hope that's okay with you guys. When you're dealing with lawyers, you really have to be careful. So that's all I have to say. I hope we are fine and we can't wait to meet you next time. Who would like to pray for us today? Let's have someone praying for us coming from your side. Anyone? At least
Let's pray.
Okay.
Our Heavenly Father, we thank you for this lovely night. Kindly protect us as we go through our sessions. Guide us through. Give us a mind that never forget, and you remind us whenever we are required to answer any question. Kindly bless our brothers who offer themselves to help us just voluntarily. That is the heart we want. We are here for each other, as you say it in the Bible, that you help your brother so that I can help you. In Jesus' name I pray. Amen.
Amen. Amen.
Amen.
Amen.
Amen.
Amen.
Amen.
Yes.
Amen. Thank you. All right. There, someone has raised their hand or something. Kibi.
It was Kibi.
No, good evening. I wanted to pray, but Lual prayed, so it is okay.
So probably next time you'll open to us.
Ayeko, what do you want to say?
Sorry, I unmuted to say amen, but I'm enjoying the session. Probably will be on the dock in the next coming sessions.
Very well.
Thank you. Thank you. Good work. Appreciated. God bless you.
Daniel and Angelo, thank you very much. Have a good week.
You too. Good week.